Regulations, Public Policy, Data Privacy, M&A, Deloitte. May I invite Mr. Anirudh Chaturvedi, Legal Operations Associate, Manastu Space Technologies. Warm welcome. May I invite Ms. Rimali Batra, Partner, DSK Legal. Warm welcome to you, ma'am. I would once again invite Mr. Abhishek Malhotra, Managing Partner, TMT Law Practice, and Mr. Goldie Dhama, Partner, Regulations, Public Policy, Data Privacy, M&A, Deloitte. So, ladies and gentlemen, a warm welcome to this session on revisiting space laws for the new space. Revisiting space laws for new space is essential to ensure that the industry can continue to grow and innovate while also ensuring the safety of space activities and protecting the interest of all stakeholders involved. It is a complex and challenging task that requires international cooperation and collaboration between governments, industry, and the other stakeholders. So, ladies and gentlemen, the time duration for this session is approximately 1 hour 20 minutes, which includes the opening and closing remarks by the distinguished chair and moderator, and followed by the moderated panel discussion. So, with those words of introduction, I now hand over to our chair, Dr. Ranjana Kaul, to kindly carry forward the proceedings of this session. Over to you, ma'am.
Good afternoon, and thank you for being here. I don't know whether the audience, which is quite clearly focused and trying to understand how to navigate the regulatory framework or the policy frameworks that have come about. So the title is Revisiting. What was that? Revisiting Space Laws for New Space. Now the thing is this, at the moment we don't have space laws. So let me just say revisiting the space policies for new space, because that is the way in which we have been proceeding. Since the point is to revisit, I would suggest to my colleagues here, and to all of you, if you'll allow me, let's just get back to the drawing board. All of us have seen the draft Space Activities Bill. Some have seen the amendment of it. These were before the announcement of the space reforms by the Prime Minister. And since then, we have seen numerous policies, draft policies, that have been issued by Department of Space or InSpace. And the last one of which is the 23, which all of us have seen. So starting from there, the starting point of it is to revisit the substance and the content of the Prime Minister's announcement. And that has the following points. India has advanced space capability. The Cabinet has decided to leverage that advanced space capability by boosting the participation of the private sector in all aspects of space activities, which is to say ground segment, manufacturing, etc., and the space segment, which is the launch, operation, and the re-entry. That it is in pursuance of Atmanirbhar, the policy of Atmanirbhar that this government is promoting, self-reliance, and that this new entity called InSpace, the Indian Space Promotion and Authorization Center, was constituted in order to assist the new space companies, the new private sector companies that had come up. So now when I look at all the policies that have gone before us, I find that what has happened is that the construct of the announcement has not been deconstructed into implementation. What has, however, happened is on an immediate basis, the Department of Space hit the road running. They have taken many steps. InSpace has done likewise, and one has to acknowledge very much the work that InSpace is doing, and particularly the robustness that the system has acquired under the leadership of Dr. Goenka to help, to assist to advise and to guide new space companies to undertake the necessary tests that are required to be undertaken, the orbital test vehicles and allowing them to undertake on-orbit tests, and basically to get them to a stage where they are now ready for the commercial launch. And then what happens? As we know, many of our new space companies that have really made waves internationally, penultimate to that, reaching that point where they will be ready for commercial launch, corporate restructuring is undertaken. Many of us advise on the subject, and this is what we do advise. There is no law as yet. So corporate restructuring takes place. A new entity is established in a jurisdiction outside India, which has enabling laws, frameworks, so forth. And they go there and they launch. Now that is what has to be reversed. And I believe that that would likely be the intention of the government to do, to close the loop. But above and beyond on this, what I have figured out is, and beyond all these very wonderful projections that internationally renowned consulting firms provide us with, God knows how many trillions of dollars of economy by 2025 and so forth, we are in 2023. So let me say this, that let us revisit the constructs of the announcement. So firstly, why is it that we want new space? I would say we want new space, hopefully, because we have identified the space sector, the commercial space sector, as the driving force for the nation's economy in the course within the framework of the next 30 years. We have not yet been provided clarity of exactly where it starts and where it ends. And in those 30 years, I would suggest decadal plans, 10-year plans, with an objective. The 10 years be broken up in 5 years. So if I'm looking at 2020 to 2050, well, 2020 to 2030, that's 10 years, and 25, the first milestone within that first 10-year plan. And we know all the things that have happened since 2020, and which is that the Department of Space, which has articulated its intention to exit manufacturing, is rapidly moving that out into the big companies that have always been part of the procurement system of the Department of Space and have delivered unfailingly. In these contracts and in these that have been given, many of our new space companies have been able to participate. That's part one. The second, and which we know, although it's not specifically articulated, we do know this, that almost 60% of India's transponder capacity is rented on foreign satellites. So if I'm thinking of Atmanirbhar, I imagine that there is a plan in place to reduce that, and I think the demand-based satellites that are being built may be sort of step in that direction. So these things we do know. Tata Play has been the first such satellite that was launched and transferred on orbit to the company. And in space, of course, I've just told you. So I want you to give us your thoughts about policy framework for establishing and developing a commercial space sector in India, and tell us what you think those contours should be like. And I'm going to now come there because then, yes, please do.
I'm just going to take a minute to adjust this. Okay. Thank you so much. And it's a pleasure to have ma'am on the chair, of course. And it obviously calls for, a lot of ownership here when we are addressing the chair and, of course, the gathering here. Let me begin by saying, so firstly, just introducing myself a little before I get diving into the space. So I'm Rimali, and I'm a partner with DSK Legal. I work in the space of regulation, regulators, and policy. That has been my practice area ever since I've seen regulation boom in the country. Regulation isn't very old, if I can put it that way. Because I remember when I started reading regulation, when I was a student of regulation in regulatory space, I started with finance regulation. And I realized it wasn't very enticing, as much as it was in the other booming sectors and spaces which were actually picking up. For instance, electricity, oil and gas, all the sectors did not have a regulator at that point in time. And the country was just opening up to private players. And that's when I realized that regulation is here to stay, regulators are here to be. And now we are looking at space. We are wanting to open space to private players, and we are wanting to bring in regulation. We're trying to make it robust, to make an ecosystem that's commercially viable and sustainable for all stakeholders. I've always been fascinated by this one quote, and I believe the governments have actually stuck to it for a long time. If something moves, anything in the economy, if it moves, the first step that the government takes is they tax it. If it keeps moving, and it's moving at a fast pace, they want to regulate it, which is when they want to bring in private players. And the moment it stops moving, it's got enough inception to all downstream, upstream sectors, the government wants to subsidize it. And we are here at the moment at a place where the government is wanting to regulate this particular point, space, which means that definitely space is a fast-moving sector at the moment. But have we done enough in our policies, like very rightly pointed out by the chair? Have our policies spoken well on the implementation of what we envisage our country to be? Do we have a vision for the next 30, 50 years? Do we have a vision for the next 5 years? Well, we understand that the policy framework doesn't go in depth of it, but yet there is lots being discussed. There is a lot already there, but a lot more to be done. From a legal standpoint, what I want to talk about today is two things. The first part of the discussion is primarily going to be about the issues and challenges that exist and how the regulatory space can enable, incentivize private participation. The second part that I want to talk about is technology and law. So moving to the first segment, which is how do we incentivize the space for private participation? Before I go into talking about incentives, let's step back a little and talk about the issues. The broad two issues that actually face us today, anybody, because I think I've been here for 3 days now, third day in process. I've interacted with so many of us here, and what I've understood is the two questions that everyone's asking is, who has the ownership, who has the right, and who takes the liability? Does our policy talk about it? Who is it that we want to give the ownership to? Our international treaties in space are very clear about ownership in space. There is none. And now we're talking about granting ownership and titles through private participation. How do we do it domestically while keeping in line with the international standards? Flip it to the other side, because the logic of right is and ownership is liability, right? I know we all know the famous dialogue, with a lot of responsibility also comes a lot of duty, right? So who takes the liability of the outer space products that we're talking about? What happens if something goes wrong? How much of it? Where do you put it? How do you segregate it? Space exploration is continuing to grow. Let me give you an example. One of the topics of discussion at the international arena has been that of debris in the orbit. We're already talking about how we can regularize it, how we can talk about liabilities of the debris, and how we can make it more available and accessible for the other satellites that are going to go up there. But at the same time, when we include private players in the sector who are definitely going to incentivize all the money that they are going to put in, which comes with a lot of experimentation and a high capital incentive innovation, we need to also talk about the liabilities associated with it and who really takes the liability for these products. If it is going to be the governmental agencies, then we need to pin it accordingly and give the incentive to the private players. But how much of it? So these are the questions which our policy needs to talk about while it talks about the years of implementation. Now, before going into further details of how we can align these rights and liabilities and what we can do to make it more incentive-centric, I want to now talk about the whole concept of law and technology. You know, unlike the question, the very old question of which came first, chicken or the egg, it's answerable in the case of law and technology. It's always the technology first. Technology comes first, law follows. But by the time the law follows, the technology upgrades. So what we are trying to do through law, there was a study conducted by Harvard. They looked at all the technological advancements in the world. Something as simple as converting your fire lighters to electric lighters on the gas. Basic technological advancements. What they observed was the government always starts with various options to incentivize the sector for private players. But when you systematically study those incentives, it rings hollow. Having said that, most of the incentives offered are negative covenants, negative incentives. There are very less inbuilt positive incentives. And this is the space how technology occupies. So the question that we ask ourselves is, we know the issues, we know we want to implement it, we know how law and technology have probably been in a live-in relationship, can't call them married. So how do we move on from here and find a way forward for setting up a regulatory regime in our country for space law? Some of the suggestions that have been discussed and offered in the past few years in multiple reports is, let us have an online web portal where all compliances, approvals can come in quick. Yes, that could be a possibility. Let us make one nodal agency which processes all approvals and licenses. Okay, let us give open access to the infrastructure that's available with ISRO. Let us put the R&D out there so that everybody can use to their benefit. But the suggestion that one needs to really look at is legislating this in our country. Do we need a space legislation, a designated, dedicated space legislation with a regulator like in space, which has certain obligations, is autonomous, to carry forward the platform of private participation so that private players know what is the risk, how much is it, and till what time. Also, what needs to be inbuilt is a dispute resolution mechanism, which probably is still, for the domestic operations, not yet thought of. Having a dispute resolution or a grievance redressal mechanism would also aid a long way in resolving this faster and quicker. Let me just put it this way. So, like I said in the beginning, I've worked with ministries in the past, setting up regulators, and it has been fascinating to see how government wants to give it all, but hold it all at the same time. But a regulator provides for that balanced space, and maybe it is time to think of a standalone act where this regulatory body can be set up. I'd be happy to take any questions at the end of the topic. Yes, at the end of it all. Thank you so much, ma'am. Thank you, everyone.
They're all on? Yes. Oh, great. So, Rimali, thank you. Very interesting things that you spoke about. So here is my view. So firstly, you've spoken about liability, which is a very, very important aspect of undertaking activities in outer space for those that are operating satellites. And that is a very precise prescription that is provided in the Outer Space Treaty, where the state is liable for itself and on behalf of its non-government entities, so private sector. And in for damage, which is caused on our orbit to the space object of another country, in airspace or on the Earth. Now, there are different types of liability. In outer space, it is fault-based liability. In airspace, it's absolute liability. Now, and on the Earth, it's absolute. So what is the difference here? Now, the thing is this, we need to understand that when we have international treaties, not all countries follow Anglo-Saxon jurisprudence. So they don't have the law of torts the same as we do. They follow the civil code. And that is the distinction between the law of torts and the law of delict. Now, delict is pretty straightforward. You're in an aircraft, the aircraft crashed, you are dead, your estate will inherit up to X threshold of compensation, and the quantum of damages will be calculated as per your age, what you do, the usual formula that we have. But if there is somebody who says that, no, this is not enough, it's the aircraft's fault, it is the pilot's fault, and so forth, then you go outside that framework and you go into fault-based liability. So that can be any quantum, and normally everyone's looking to somehow get US jurisdiction because they're very, very generous. So similarly, outer space, fault-based. This is why you need SSA, SDM, you need to be able to track what is happening, kiskne kisko pehle mara, who did not undertake collision avoidance maneuver. What are the rules that govern the role of the rules of the road for this matter? Problem that arises is that over the last 20 years, because of geopolitical rivalries escalating, and now with 3 superpowers, there has been an absence of consensus in the Committee on Peaceful Uses of Outer Space. Now, as a consequence of that, these humongous constellations that are going to provide us broadband services, thousands of satellites in one constellation. Well, nobody knows what the rules of the road are. In the old, classical days before these constellations, there was what I will simply call a pehle aap culture, in the sense that if there was an existing satellite orbiting, then the new entrant would be the one to do the maneuver, allow the old to go, it becomes old, and then a new one comes. We have seen recently the proliferation of non-government entities who are global companies and have got very advanced technologies with which they've built their satellite systems, simply not bothered about all such niceties. And in one case, the European satellite, which would, in normal circumstances, would have been allowed to pass because it has been on orbit for a long time. Well, this young space company said, well, it's just too bad, you do what you want. And there was a lot of consternation. But these kinds of things increase a certain feeling that there might be an accident happening before you even know it. Nobody knows how you will exactly identify that. Why? Because the registration convention, although it requires a country to register that space object and provide very detailed information to the UN registry, don't do it. Why? They don't do it on immediate basis because it says as soon as possible, as much as feasible. So I could register an object 10 years later, 12 years later, whatever. Whereas the COSPAR maintains a registry because you cannot have a satellite without an identifier. It's like the registration of your car. And the US, NORAD, keeps the most comprehensive and open database to a very large extent so that you know which our companies are able to track that. It's a very difficult thing, as yet it has not happened. And God help us if it does, because the collateral damage is going to be humongous. Then you have airspace. And then you have on Earth. We've had 2 instances. Fortunately, there was no loss of, death or harm that was caused on Earth. So that is as far as liability goes. The second, you spoke about a regulator. Now, what we need to clearly understand is authorization and continuing supervision is a requirement under Article 6 of Outer Space Treaty. For the state, it is an international responsibility of our country. And so therefore, now what does authorization mean? Let's not get stuck on the word. Authorization means permission, letter of authority, license. Basically, the state saying, yes, you may. In context to launching in orbit a space object, there are many stages. You might first have authorization, your application is evaluated, and you have authorization to establish your system. subject to half a dozen terms and conditions. Most people, mostly you don't, it's difficult to make a perfect application. The application will go to the WPC, they will look at it from spectrum angle, so forth. And after you have ticked all the boxes and all the technical aspects have been, then the licensor will issue a license to operate. Is InSpace going to be the licensor? I don't think so. It functions under the authority of Department of Space. And when you look at our closest sector, which is telecommunications, satellite telecommunication, who is the licensor? Who grants a service license? It is the DOT, Department of Telecom. Under the allocation of business rule, it is DOT which is authorized. And I'm almost certain, and I may be wrong, it is the Department of Space which will be the licensor for space objects. It is the one which deals with the United Nations in these matters. And the third which you will distinguish is the regulator. Now again, the closest is the TRAI. Unlike in the past when satellite telecommunications was announced and introduced in the country, the government of India had taken the decision to partially deregulate many sectors. So they had a plan, they worked out on the telecom, whatever the adjustments and amendments to the law, they got a new law in place to set up the TRAI. They then created a policy framework for implementation, because the job of Department of Space is to provide the hardware. You need transponder capacity to be provided to the commercial telecom operators and broadcast operators. And that is how it started. So in 2000, those guides and norms and so forth came. So the point of the matter here is that this is a whole system that has to be put in place. And the regulator is somebody who will have the experience and ability to be able to put a draft out, to undertake the mandatory, fulfill the mandatory requirement of public consultation. Right now what is happening is the draft is put out once, you're told that in 15 days, 20 days, 1 month, whatever, please give your comments, and you don't hear about it again. And then you have a draft policy that is issued. That is not, I mean, that's only ticking in the box. Now we're getting serious here. We are going to have a commercial space sector. So, my suggestion would be that TRAI is already doing cyber, it is doing several related verticals, it should do space because it is very closely connected. And this is not a case of turf war, it is just to get efficiency. And for dispute redressal, you would know very well that there was a litigation which said that, DOT cannot possibly be the one who will look upon its own license or its own terms and conditions if I, the applicant, has a problem. Judge and jury ek to ho nahi sakta hai. So then they said, all right, we'll give it to TRAI. Now TRAI issues a direction in the matter, now it cannot be the judge and jury. So you had another round of litigations and you got the TDSAT. And the appeal from TDSAT lies in Supreme Court. So we have to think this through and then do it. Now, of course, in the recent past, we know that there is a lot of energy to find out how it is that defense and private sector space companies can come together to synergize and to help each other. And Anirudh, if you're able to tell us something about that, your thoughts on it, please do.
Good afternoon, everyone. I am Anirudh Chaturvedi, and I take care of legal operations at Manastu Space Technologies. This brief introduction I would like to give before beginning with answering the question raised by the chair. So we develop propulsion systems for satellites. So we basically are a subcomponent, subsystem manufacturer for satellite operators and launch vehicle manufacturers. Now, dealing with defense whenever, let's say, for example, you sign a contract with DRDO, or for that matter, if you win an IDEX grant. First of all, the challenge which we face as private entities is that you do not have any negotiating power or control over that contract. Whatever terms are presented to you in that contract, you abide by it. Most of the times, the terms which are provided therein are not, say, detrimental to the private entities. And of course, since defense is related to national security and critical information, sensitive information, these contracts do need to have greater control over sharing of IP, sharing of information, change in corporate structure of the company, directorship, investment, etc. But what becomes slightly difficult for the private entity, and this is what I have seen in my limited experience at the company, is whenever you have certain obligations under a defense contract that you have signed, and then of course most of the companies in India are startups. They raise funds from venture capitalists, from institutional investors. So whenever you are negotiating your shareholder agreements and other rights and obligations of the company along with your investors, then at times there are conflicts in terms of ownership of IP, sale of IP, licensing, etc. And this becomes slightly difficult for the private entities to negotiate, because you already have an obligation from the government, and which at times can be overarching. And what happens is that then you have to very clearly diversify what kind of products that you're working on, diversify your business in terms of what you will do for the defense and what you will do in terms of commercial space business. So that becomes a bit of a challenge. One example which I could cite is, at times when you sign a defense contract, they normally have clauses such as export guidelines of the Ministry of Defense will be applicable whenever you are selling your product to a foreign entity. Now, if we talk about NewSpace, the development, why ISRO handed over some of the tasks, some of the development things to private entities, is that it could focus on bigger things. It could focus on things which it has not already mastered. Now, when private entities, they are developing such things, they also should be able to sell it out of India, and it should not just be limited to the Indian market. Now, what happens is, when you have these kind of overarching obligations wherein you are not clear as to which particular guideline, like I cited the example of Ministry of Defense's export guidelines being applicable, you do not clearly know, nothing has been pointed out that which specific guideline would be applicable. It becomes slightly difficult to understand the complete impact of the clause on your product, on your business, on your future ambitions. So that is something which I feel becomes slightly difficult for the private companies to encounter. And secondly, this is not a law point, rather a practical point. That is, once you start working with the defense, of course, it is for a company to be able to serve its country's defense sector is very good, and we indeed want to do that. But what happens is, at times when you start working with defense, and then you parallelly try to work with private sectors, or let's say source out some of the materials, because most of the vendors are not, raw materials vendors are not available locally in India. Then when you start dealing with countries, jurisdictions wherein such things are available or such kind of support is available, what happens is, since you are working with defense, and if it is a public information, they do not tend to help you out. the support goes away in such scenarios. So there should be, something should be done in terms of, international collaboration between the states and between the regulators in order to make it slightly easier for the NGs to work in collaboration with both defense as well as civilian aerospace. So that's it. Thank you.
Thank you. So thank you. Rimali and Anirudh, you have made very, very pertinent points. A synergy between defense and civil is so much the need of the hour, and there is a lot of conversation around it. So the thing is this is my take on the gap, which is an institutional gap, and it's a gap in approach. So the civil space, all the young space companies, they are people who are young, they've had an idea, they found the money, beg, borrow, steal, uncle, aunt, friends, whatever. They got it together, they took the risk, and I've had many young of them coming and saying, ma'am, I don't know what to do. My father says, forget about all this, I've given you enough time, get a job, get married, settle down. So there isn't just the one problem that these young people are facing, they're facing parents. So now that is a major problem in most young people's life. Don't laugh, I think you... So be that as it may, overcoming all these hurdles, there they are. And then, fortunately, because of government's policy, you have got now educational institutions, our universities, which are setting up incubators, and they're helping these young students to come up with ideas and then move on with those. So what it is that these are people for whom time is of the essence. If I'm raising funds as a pre-seed funding or seed funding, not that anybody understands what it means, it's truly rocket science. I mean, really, for heaven's sake, I'm a humanities student. So it becomes virtually impossible for the defense sector or the commercial or the civil space sector to actually wrap their head around all these fancy terms. And here are these people, most of whom are not yet 30. And you're thinking to yourself, really? Really? Is this what you're telling me? I've been in the job for the last 30 years. But of course you can't say it. And so you're paternalistic and say, ha beta, aa jao, baitho, let me have a Coca-Cola, have something, have a coffee. So that's one part. All of them, of course, think that, oh my God, it will just go round and round in circles from one desk to the other desk and so forth, so forth, so forth, and you'll never hear it. On the other side, this is the approach. Point of the matter is we need to respect each other. And I think, as a suggestion to InSpace, if there's anybody here from InSpace, my suggestion is that as these companies are undertaking their tests, then on orbit, please issue a, what should I say, 1 star when you finish one level, the 2 stars when you finish the second level, karte, whatever, 3 stars, 4 stars, and then at a point in time, depending on the technology being developed, to say that now ready for commercial launch. And on your sides, anybody who knows all about finance and raising funds, please put down against each of those what are the different types of funding that are taken. And so if people, ignoramuses such as myself, I'm reading this chart and you say, I know, okay, fine. So this is the money he's raising. Now, typically what happens is at the end of the day, because funds have to be raised, and because every single milestone has to be achieved, otherwise you're in deep trouble. You've got a huge debt sitting on you. Therefore, at the end of the day, the companies end up diluting about 70% of the equity where they started with 100. That is a matter of concern, at least at this moment, for the defense, which says that, if it's 70%, this means there's some foreign company that actually owns them, and what happens to the IPR? You have to work this through. At the same time, and I will have to say this, even if The defense is acquiring several services or products which are imported through wholly owned subsidiaries established in India, and on the basis that the defense, whatever the regulations are, say that if it's wholly owned subsidiary registered in India under Companies Act, it is an Indian company. So if that is the case, and this is the case, then it's for the defense services to work around that proposition. It's not for me to, but I'm just saying that it's somewhat incongruous. There will have to be a way to work out. Or you want to keep control, please let the government finance these companies. You give them the finance to build these, but you don't want to do that because there's paucity of funds in the country. So you said, you put 100, I will give you 100. And it goes as per milestone. That is IDEX model. It's great. I mean, at least we are moving forward. But we have to look at the genuine problems that are preventing us from really synergizing. Now I'm going to ask Ashok to make his remarks. I don't have to say anything further to him. He's been my fellow traveler. Thank you.
So I think as a speaker, I've been told by my wife that the lesser I speak, the more interesting I am. So I'm going to try and keep my note to as brief a summary as possible. I think the dialogue between all of us who are interested in policy reforms and the establishment, be it NewSpace or ISRO or DOS, what we have to first acknowledge is that I've been in this sector from 2014. I'm relatively new. 2014 to 2020 is phase one of my career as a space lawyer, and 2020 to 2023 is my current ongoing phase. And the amount of movement, progress, and excitement that I've seen from 2020 to 2023 in 3 years, I hadn't seen it from 2014 to 2020. Right? So first things first, I think we need to give credit where credit is due. There has been a lot of movement. There's a lot of interest. There is a lot of good intention. And I think the effort will be equally on all of our part to see how we can work with the establishment to try and see what progress we can achieve and how to give impetus to some of the initiatives that the government wants to take. Now, one of the most heartening developments, I think, is the guidelines on authorization that NewSpace very recently released. I think it was just about a week old. And there are several aspects of that policy, of course, and because of paucity of time, I'll not go into all of them. But just to give you a sense of how responsive the government has been, one of the asks that the industry has always made is let licensing / authorization / bureaucratic frameworks for any of these authorization-related activities, let it be time-bound. Now, if you look at clause 3 of the general terms and conditions of the recently released authorization guidelines, there is a time frame of 4.5 months that NewSpace has committed to, saying that once you submit your application, it will be time-bound and we'll try and meet this deadline. Okay, there is a caveat to it, which I'll come to a little later in the day. The second thing is responsiveness. We have always said that, look, ultimately any regulator, and I'm sure my co-panelists will also agree, any regulator is ultimately governed by the dictates and mandates of the Constitution. They have to exercise their discretion in a particular manner. They need to have policy frameworks for the exercise of those discretion. So we always kept advocating that, look, if somebody is going to get the task of licensing or authorization, specify what factors they can consider, what are the relevant factors they need to consider, what are the irrelevant factors they need to ignore, and let them have a clear framework for exercising the discretion in this manner. Because a decision taken in contravention of this violates Article 14, which then invites the Supreme Court to do what it did in the 2G spectrum case. Right? And you comply with these factors, and then chances are that you won't have to deal with judicial review. Now, page 3 of the authorization guidelines actually mentions some of the parameters that will be considered for reviewing and providing those authorizations. So clearly, somebody within the establishment is listening. The most heartening element for me was on the subject of liability. As you heard from Dr. Kaul, this is an extremely complicated subject and a source of considerable concern for startups. Because if liability is as uncertain, insurance becomes very, very expensive. Now, if you look at the liability guidelines that's come out in the authorization, you will see in page 20, clause 3, if I'm not mistaken, that if it's an Indian payload on an Indian launcher, the government is now saying we have no expectation of insurance. If there is liability, the government of India will pay for it. And this by far is a greatest statement on the part of the government that we will work with startups and we are here to not just regulate, but we are also here to promote and encourage. Right? Page 19, there is yet another element which is interesting, which says that if your insurance excludes a particular form of liability or you cross the liability limit of the insurance policy, what is covered by the exclusions and what crosses the limit, the government will again pay for it. Right? Now, all of this to my mind indicates that I think the government is beginning to walk the talk. They are quite serious about ensuring that whatever they announced in 2020 will be given shape, structure, and form. Right? Now, of course, now that I've pointed out the positives, lest I sound like a pro-establishment in the interest of also being critical, let me also focus on a few points that will need further consideration or further review. So, for example, we are talking about how there is a 4.5-month time frame. Now, there is a caveat to that statement, which is subject to prompt feedback coming from other departments and other ministries who also have jurisdiction over space activities. This brings me to a very important point. I understand that there are turf wars between the departments. I understand each ministry has its own expectations and each ministry or department is not willing to cede any ground to the other. But what we need is some form of regulatory aggregation. So it's great to say DOT will look at orbital slots, DOT will look at frequency and spectrum, and DOS will look at the other upstream elements of the whole program. But what we don't want is a situation where somebody like Anirudh, who is advising a company, has to look at multiple circulars, multiple notifications, multiple guidelines from multiple departments. Right? If that regulatory aggregation is not achieved, then the 4.5-month time frame that InSpace has committed to may just become very difficult to achieve in practice. So what we need is some form of packaging of these guidelines where we say that space industry will be governed by a particular code which will comprise of DOT, DOS, and all the other applicable rules and regulations so that somebody like Anirudh can look at one place and knows exactly what he needs to do and what he shouldn't do. Right? Now, the other aspect of the matter is that you have announcements over announcements, you have policies over policies, you have notifications after notifications, but which is the one that actually prevails? The issue of supersession of these policies then becomes very important because you have the 2000 policy, which is the foundation of this entire conversation. You have the 2020 announcements and the draft SpaceCom policies, the draft remote sensing policies, so on and so forth. You have a space policy of 2023, and now you have the guidelines for authorization, which, by the way, makes references to further guidelines and standards to emerge. Right? So we are going to operate in a system where there are multiple documents to look at before you say which is applicable, which is not, and what should I comply with. Now, it's very important for the policy to specify which is the one that will ultimately prevail. And I'll give you an example. The data dissemination policy, which has been announced as part of the authorizations last week, talks about how data dissemination when it comes to geospatial data or Earth observation data will be regulated. There is also a somewhat overlapping policy for geospatial data by the Department of Science and Technology. Now, if I am a lawyer and if I have to look at two different documents seemingly governing the same aspect, I don't know which is the one that will prevail, especially if there's a conflict. And my job is not made any easier by the fact that the principles of interpretation says that both laws are equally applicable and I must harmoniously construct both of them. So these kind of constraints being imposed on either the lawyers or the industry, I don't think is going to really make the kind of impact it does. But again, going back to my earlier point, the establishment is listening. The establishment is willing to learn. The establishment wants to work with industry. And as the chairman of one of the directors of InSpace who was here candidly admitted, they even have difficulty setting up the legal directorate because of budgetary constraints. right? And you have to also look at it from their point of view. Here it is a case where InSpace is saying that as of 2023, they will sit and define what each stakeholder in the space program will do. The establishment, that is ISRO, the overarching authority, which is Department of Space, the NewSpace India Limited, and InSpace, and then there is also the private sector. To unsettle a setup that's been ongoing for the last 50, 60 years and say that each of you will be having this role and responsibility is not easy. But they're taken up that challenge and they've actually managed to deliver a document which of course has been criticized, but I think we need to give them credit for that. The last point that I like to make, I think, and this is the most serious concern that we have had, which I think is still not addressed. Time and again, the Indian Space Policy of 2023 says that InSpace is autonomous. Right? But the question arises, if InSpace decides to authorize and DOS or DOT does not agree to license, does the decision of InSpace prevail or does the decision of DOS or DOT prevail? And the answer to that question is DOS and DOT will prevail. If that is the case, InSpace is not autonomous. It says single window agency, but fact of the matter is that all the ministries have their own guidelines, all the ministries have their own paperwork, though that paperwork will continue to prevail. So which means it is not a single window clearance agency either. It just becomes the front desk where you deposit your application forms and they will follow up on your behalf, and which they've done very admirably. But if the InSpace as a regulator or as a promoter or whatever you want to call them is not autonomous, then the conflict of interest, which is the establishment being a competitor in the space economy, as well as a regulator of the space economy, continues to remain, because Section 8 of the policy also says DOS can redistribute those powers and responsibilities. So what is the guarantee that InSpace will not be divested of these powers at a later date? So I think somewhere we also need to realize that if we want a clear and predictable space policy which has the effect of attracting capital, these kind of contradictions and usage of words that is not backed by the substance of the policy, we need to avoid that. And if you are able to address these small little tweaks that are still needed, and if you're able to kind of work in a sort of a partnership atmosphere, as opposed to an atmosphere of acrimony, I think we can actually ensure that the space industry gets the encouragement it does. Right? And in the panel in front of you, you will see that space law and policy professionals come from different age, different backgrounds, different sorts of qualifications, right? My personal opinion is that if a person with experience in a particular field of law has an edge over a person with inexperience, then the language of the policy requires correction. Because it should not be based on how much of experience you have had, but it should be based on how easily you're able to read the law and decipher what is applicable. And I think if we're able to achieve that objective, we should be able to carry the vision statement, and as Ranjana ma'am rightly pointed out, we can then look at how effectively we can implement what we have set out to do. Thank you.
So of course, you have heard from all of us. The one thing that becomes clear is there has been progress, no doubt. One gap is the coordination in context to implementation of that space policy. And that would be Department of, well, now it is at the moment only WPC. DOT is not particularly involved at this moment. But ultimately, when you say that we will allow private sector to launch satellites, what do you mean exactly? So I launch a satellite, what are the services that I might be able to provide? So let's say telecom and remote sensing. If it is telecom, quite clearly then, that proposition must be aligned with the DOT, with the digital communications policy. It should be aligned with WPC, and it should be a seamless connection so that I can provide telecom service. The second part is that because we are trying to exit from the canalized mechanism through which we are providing transponder capacity right now to our commercial telecom and broadcasters, if there is a big company which has manufacturing, where you know that we have legacy manufacturing companies and producing, if such a company wants to actually become a satellite operator, call it INSAT if you like, let him then rent out the transponders to whoever is the commercial service provider. Will you allow such a thing to happen? Can the satellite be owned fractionally? Maybe 3 or 4 people get together and they want to do it. Can the transponders be rented out fractionally? Somebody wants 2, somebody wants 3. Is that possible? Will that augment INSAT capacity? And of course, INSAT will perhaps provide ground and tracking and telemetry services. So it's not only earning revenue out of constructing, launching, everything else, but also out of providing ground stations. But here is a chap who's being able to get revenue out of it. Is this possible? What about remote sensing? Will I be able to run a business to export my data to foreign countries because I want to make it? The question is not that IPR will become somebody else's. The question is, what are the specs that the defense wants, for example? Then there is contractual terms. I mean, you have lawyers sitting over here, I'm a lawyer. What is the mechanism and the contractual terms by which that particular resolution is not capable of being provided to anybody else? That is your issue. If you say that I want every hour, data every hour, and I want somebody who will integrate all this data so that I'm reading it on my handheld device all the time on the border, because I have to now go and have a meeting with the opposite commanders from the opposite side. Are you being able to get that? Can you get that? Yes, you can. But you have to think about how you will enable your own self. We will enable us. It's not you, it's all of us, because you do everything you do for us. These are aspects that need to be sorted out. And most of all, when you come up with the revisited policy, let's not go all over the place. Just keep it precise, to the point, make it work. What is the point of saying that you can launch from a private spaceport or a lease spaceport? To the best of my knowledge, there is only the government spaceport. Is it possible? I mean, yes, it's possible somewhere in the future. But to simply borrow an idea, perhaps from Richard Branson, who has rented about 1,500 acres of land from Spaceport America, or Mr. Bezos, who's actually bought up a little township and God knows how many thousand acres and set up his spaceport. Yes, maybe somewhere down the line, across the rainbow perhaps. But at this moment, is that relevant at all in a policy? I think we should shed all these things and just focus on what needs to be achieved. And let's get the job done. Thank you very much. Sorry?
Questions from the audience.
Yes, of course, questions, without saying.
Deepak Maheshwar, Senior Visiting Fellow with a career. Just want to mention one specific fact of historical fact, maybe you can say. So since 2000, ISPs had been permitted to use foreign satellites contract directly, not through ISRO as a canalizing agency, as is for VSATs and for others. And that was one particular thing which, of course, did happen at that point of time. Now, there's a precedence. Perhaps there's also an opportunity here again to do this type of similar type of arrangements, again, without bringing ISRO as a canalizing agency, but just as a facilitator. Thank you.
I didn't quite get the whole thing because there was a lot of resonance of your voice. So can somebody interpret that for me without...
Should I just repeat? Is it okay now? What I'm saying is, ISPs had been permitted to set up international gateways using satellites since 2000. And those satellites, when they were setting up these satellite gateways, they could contract directly with foreign satellite operators. And I mean, some of the people within this room, for that matter, had been involved also in that with different companies. So There were Intelsat, of course. There was Singtel, NSS, JSAT, many satellites, Thaicom, etc. And different ISPs had used those directly, I'm saying. Okay. Of course, we had to go through WPC process, everything. But the commercial contracts could be done directly. So there's a precedence. That's all I'm saying.
Thank you.
Ma'am, I'm Hardik. I'm a student of International Studies from Jawaharlal Nehru University. So, ma'am, my question is, a lot of, like, the speakers alluded to creating a regulator for space industry. So, is it really possible to have a single regulator for space industry? Because we have different applications and different segments. So, how do we proceed with that? Because regarding telecom, there is already a tussle between DOS and DOT. Regarding other functions, remote sensing, for example, there has to be some other regulator. So is it possible to have a single regulator, or how do we go with that? Thank you.
Answer that? Well, no, I think that there's no point having multiple regulators where one regulator is within the domain sphere, which is the TRAI. In our case, space, TRAI. Telecom Regulatory Authority is now at the moment trying to figure out what to do about spectrum auctions or administratively. It is also a regulator for cyber. It is also a regulator for airports. Although there is an airport economic regulatory authority for private airports. I think the space sector and satellites is intrinsically linked downstream. And I would believe that that could be the way to go. I don't think you need so many multiple where one is possible.
If I can just add to what ma'am said, I sort of completely concur with the fact that we can't have, obviously, first to answer your question, we can't have one single regulator considering how varied the space is and kind of bodies that are involved. But let's draw some parallels and analogies to other sectors where there is upstream and downstream work that's happening. Let me do a parallel with oil and gas for a minute. It's a different sector and I'll come to try also. So in oil and gas, we know there is upstream exploration happening, licensing happening, open acreage policies. Regulator is the DGH, which is the nodal agency for only monitoring upstream activities. And then we come to downstream, which is the interaction with the consumer, the final supply to the end. As of today, we only see certain given benefits of the satellites like we talk about. We're probably also seeing a blue economy, maybe more in the oceans. Maybe there's going to be more work with education in schools to come with. These satellites could not just be limited to certain space. So consumer space is going to expand. When we talk about downstream, we could think of a separate regulator there, just like oil and gas has PNGRB. Now, when we talk about downstream, there ma'am mentioned we have TRAI, and rightly so, because there is an interface. But the question is, as we mature in the space sector, would it be okay to house the regulator within TRAI, given the way TRAI is structured today, given the functions that it performs, or would it be ideal to have a standalone regulator considering the other departments that are involved apart from what TRAI deals with? Now, let me give you another example. Railways does not have a regulator. Railways as of today is primarily with the government. While we've been working with the government for a while now to bring in an independent regulator, and the announcement happened 15 years hence from today that they wanted an independent regulator, TRAI's appellate body, rightly so, was considered to be the regulator where they could house the railways regulator also. Why? Because the airports regulator goes for appeal to TDSAT, right? Having said that, railways still came to a conclusion that we can't go ahead and house our regulator within an existing regulator. And they decided to have an independent regulator, maybe appeal still going back to the TRAI's appellate body. So the question beckons, we don't need multiples for sure, but we need to identify as the space matures, can we bifurcate upstream, downstream the way it is? Can in space, like the question of licensing, like rightly pointed out, who's the licensor at the moment? And if the licensor is the government, what is InSpace role in that license? Does it take all the stakeholders in it and basically provide for regulation to control their behavior patterns, provide them the manner in which they can operate, provide them the regulations for risks and rights? So what is the role in upstream, and how do we let InSpace work in downstream? So the question remains not multiple regulators, but how can we have an autonomous body, which is not particularly InSpace at the moment, which could actually create that level playing field. That's my take on it.
Yeah, just want to respond to one thing to the chair with due respect. You did mention that TRA is also the regulator for cyber as well as for airports. To the best of my understanding, it is not. Yes, TDSAT is the appellate tribunal for both cyber and for airport economic regulatory authority, but not TRAI itself is not. That's all. Thank you.
Thank you.
I am Abhishek Singh from Defense Space Agency, ma'am. I just wanted to ask regarding the Artemis Accord, which has been recently signed by the Indian government.
Speak a bit louder.
Yes, ma'am. So I wanted to ask about the Artemis Accord, which the Indian government has signed. I just wanted to know if you can throw some light on how do we define the area of operation, as in if the law has to function, then there has to be a general area where the law works. So when it comes to Air Force, we can understand that it governs with non-orbital dynamics. Then we go into a space where the orbital dynamics work. And then there is a space where it is deep space and we don't know what works. So how do you define this area or volumetric expansion where these laws will be applicable?
By laws, you're talking of the space laws? Well, the Outer Space Treaty is the ex cathedra treaty, and outer space includes the moon and celestial bodies. Now, the Outer Space Treaty is an extremely well-crafted and intricately linked treaty framework. I have never seen a framework which is quite the way that the Outer Space Treaty is, and quite honestly, it's very futuristic. There has been a criticism that the Outer Space Treaty is incomplete and that it is just not adequate because it does not govern planetary resources. Now you have to understand that the point in time when the Outer Space Treaty was legislated or was adopted by the United Nations, the time involved a trigger which is Sputnik. It is the first military communication satellite system. Now prior to that, 1945, at the end of, as the war was winding down, and after Stalingrad, it was quite clear that the Allies were the putative victors, so to speak. What did happen is that because of the discovery or the realization that the German V-2 rockets, which were guided missiles, firstly, that immediately put in the forefront outer space or very high altitude as the most desirable high ground for the military. Space is all about military, first and foremost. Second of all, as in April finally of 1945, the Western theater surrendered. The East was still active. Japan had not surrendered. And in 45, the atomic bombs were dropped on Hiroshima and Nagasaki, and so we also entered into the nuclear age. And last of all, in October, we got the United Nations. So when you look at all of these things, and mind you, by the time the war turned in favor of the Allies in 1944 already, the center of power for aviation shifted to the United States, to Chicago. There was a convention of 1944 that has provided you civil aviation. As we all know, you take your bag and travel to wherever you want to. But that framework of Chicago Convention, of course, those that were writing it were very clear about what is civil use and not civil use. So the Chicago Convention deals only with civil aviation and does not apply to military, which is why we exercise you are able to fulfill that function for us. to defend our sovereign airspace, right? So now in this case, both the Soviet Union and the Americans were undertaking hundreds and hundreds of tests and incredible speed at which technologies were being developed. By 61, you know that Yuri Gagarin had already been to space and Trechkova to follow in 63. They had undertaken several lunar probes, but not succeeded in landing a rover. Americans said they would land the first man on the moon before the... All of these treaties were being negotiated simultaneously after Sputnik, because these are nuclear power states with very superior launch capabilities. And they realized that they need a whole lot of time to actually develop those military technologies, and they needed to sort of calm down and keep the powder dry in outer space. Therefore, the Outer Space Treaty was crafted, and the first resolution was peaceful use. Now, to say non-military would have been counterproductive. No country is going to spend zillions and millions of dollars for, civil. So therefore, peaceful means all activities excepting aggressive and offensive. And institutionally, it was separated to what we call the Conference on Disarmament. On this side was Committee on Peaceful Uses of Outer Space. So as matters have progressed from there, the Outer Space Treaty, which was first, you got the Partial Test Ban Treaty, prohibiting nuclear and WMD, so forth, in outer space, under the oceans, and in atmosphere. And then, as clause by clause, the Outer Space Treaty was actually negotiated. It was adopted in December of 1966, and 67, all the countries started ratifying it. Outer Space Treaty, the objective is to control the use of technology. It's all dual use. To control the use of technology which is in the platforms which will be orbiting, and the purpose for which it will be deployed. That is the purpose. Notwithstanding that, the Outer Space Treaty extensively speaks, and particularly for your interest, Article 4 of Outer Space Treaty, which prohibits the placement of WMDs and conventional weapons and so forth in Earth's orbit, and also the placement of these such weapons or any other kind of weapons, that is to say not necessarily restricted to nuclear and WMD, on the moon, or setting up fortifications and so forth. But the Outer Space Treaty does not regulate space resources. Now, what are the space resources? Spectrum, radio frequencies, and in Earth's orbit you have the geostationary orbit. And the third is a function where you need to coordinate the uplinking, downlinking frequencies so that there is no harmful interference. That function is regulated by the International Telecommunications Union. So it allots slots in GSO, it undertakes the frequency allocation, and it allocates spectrum, which and every country has a national frequency allocation plan. And they tell you which frequencies for what. So for fixed line services and for broadcasting, so forth, so forth. And there are many frequencies in between that are not mentioned at all, which is what we use for strategic purpose. The ITU Constitution and Convention are aligned with Outer Space Treaty, so for peaceful uses. They don't deal with military sort of interference and all that kind of thing. The other resource is planetary resources. So the Moon Treaty is the one that deals with planetary resources. And what it says in Article 1 is that the Moon Treaty is applicable to the Moon and to all celestial bodies until such time as specific international treaties are made in respect to that particular celestial body. So right now, Outer Space Treaty is also applicable to Mars, which is, part of that Artemis thing. So to say that it's an imperfect treaty is really quite not true. In any event, there is nothing in Outer Space Treaty that prohibits countries, the state parties to the treaty, to go to the corpus and to work out a good mechanism by which planetary resources will be managed. Nothing prevents you. The Moon Agreement is by and large a sort of a copy-paste of the Outer Space Treaty, the common interest of mankind, province of mankind, excepting Article 11. Article 3 of Moon actually amplifies the scope of Article 4 on this business of WMDs. It also includes threat and use of threat and all that kind of thing. It's a very well articulated para 3. Article 11 of the Moon Treaty says that, of course, exploration, exploitation, commercial exploitation, all of it is enabled by the Moon. Excepting it says that at a point in time when commercial exploitation becomes feasible, then the nations of the world, those that are members of that treaty, will get together and they will put an international framework for managing. It is not providing you with any indication that you may, this has to be part of that mechanism or that should not be part, not at all. After all, the mechanism which will then govern those commercially extracted resources will have to deal with the facts on the ground at that time, whenever it may be. So in any event, the Artemis Accords, what we have signed just now and what other countries have signed, is really a very early stage, which provides you for the civil exploration and use of Moon, Mars, asteroids, so forth, and has put out 13 different propositions on how this will be regulated. For sure, there have been concerns that have been articulated by many countries, including such things as deconfliction zone and, heritage, human and robotic heritage and so forth. There are many aspects like that. It is silent about Article 4, placement of weapon systems, so forth, whatever it is. But these are very early days. And this is going to be that first phase. I don't think that, we are in any case about to launch our Chandrayaan 3. It doesn't prohibit countries from engaging in other bilaterals, undertaking their own lunar projects. That is part of international law and international treaty. So that is the way it will be. And I see no conflict in any of it, frankly.
Thank you very much. Yes, ma'am. Actually, the time is up. Sir, a quick question from you. Kindly make it very, very brief, sir.
Yeah, I'll make a very brief, madam. It's not a question and just submission, not even a suggestion also. Because some 2-3 points which were emerged in the discussions, I'm not a lawyer, I'm a scientist, I'm working in ISRO and DOS. I submit that I was part of giving some inputs in formulating this policy and guidelines and all those things. Yeah, of course, as came out in the discussion in the forum, anything which is put as a statement of the policy, it is subject to the interpretation and the time of that. Why it took from 2020, though the space sector reform was announced in the year 2020, the policy was out in the April 2023. It nearly took more than 2.5 years because all these subjects were internally discussed. It was discussed internally involving various people who handle the subject, who deal with the subject, multiple departments of the governments of India and various associations representing various industries. All those inputs were taken into account. Two things just I would like to clarify. There is nothing it prevents here, even making a partial satellite or a full satellite, owning it and all those things. Those are all the things. Maybe if there are some clarifications I may say, that maybe InSpace will be able to give the clarification as a regulator, an autonomous regulator. Second one, the point came is the need for a dispute resolution or an appellate agency. Because space, again, the in-space activity will be mostly limited to the upstream activities, and the downstream activities, again, there are dependent on, suppose if it is used for telecommunication, then it has to be abide by the DOT rules. If it is used for broadcasting, it has to be abide by the MOIB guidelines. If it is for data and all those things, it has to be covered under the geospatial. Because it was very difficult to cover everything, bring under one thing and undo what is done by other department. In a government system, it becomes really difficult. As the suggestions were made, it has to align with all the things. And with respect to the dispute resolution, again, it's not, I don't know, I'm not competent enough to make the comment that it is not the telecom resolutions which can be governed under one framework. It is perceived that this canvas is much wider. And today, if you get into what kind of disputes which can come, what is the mechanism to reduce, it is again a subject for discussion for maybe, unless you have a case which can be the basis to evolve further, it was becoming extremely difficult to put the case and make the guidelines to the way of dispute resolution. So finally, there was a suggestion that you take off, you encounter some issue, then you create a mechanism, it can be fitted into something which is already, you can refer to that. If it demands that something, some new wisdom is required. For example, if you don't know if it crashes if one object crashes into another object in the space, we are really not sure whether the existing laws will enable us to fit into that framework or whether we have to go to the international law. Those are the uncertain things. So it was, after a lot of discussions, it was decided to take off first, allow the industry to grow, allow the people to get into the field, let them encounter. When they encounter, maybe they can come back to the department or ministry. That time, maybe such things can evolve. That was the considerations within the discussions, the people who are involved in formulating the discussion. Because I was part of that, I thought I'll share that exercise with this forum. Thank you for that.
Thank you, sir.
Yeah, I absolutely agree with you that all things in good time. All these systems will have to come up in good time, whatever is appropriate for the sector. I agree with you.
Thank you. Thank you very much indeed. Ladies and gentlemen, let's put our hands together to that wonderful, insightful, interactive session we had. Thanking distinguished chair, moderator, and all the eminent panelists. We now close the proceedings of this session and break for lunch. I would request all our eminent speakers and VIPs to kindly join us for lunch here in the Oval Room, and all of the delegates are kindly requested to proceed towards the Regency Ballroom and join us there for the lunch. Thank you very much indeed, and kindly be seated back by 2:15 for the next session. Thank you.